598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr. Hurst.
we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
Welcome back to the Courtroom Chaos Corner. Today's feature is a golden gavel moment. In sovereign citizen absurdity, we've got Kevin Hurst, a self-proclaimed legal wizard armed with conspiracy buzzwords and a deep distrust of mail. And on the other side, Judge Robinson, who's got the patience of a saint and the wit of a stand-up comic. What begins as a simple civil debt case turns into a cringe-worthy crash course in legal misunderstandings as Hurst rejects discovery, babbles UCC codes, and demands verified contracts. But trust me, the way the judge breaks it all down is worth the watch. This episode isn't just entertaining, it's a textbook lesson on how not to represent yourself. And stay tuned, because by the end of this hearing, the judge delivers one of the most satisfying legal smackdowns we've seen this month.
Request for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I opened written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my.
Kevin Hurst is essentially saying, I reject your reality and substitute my own. By refusing to accept discovery documents, an absolutely crucial part of litigation, he's sabotaging his own defense. Judges and lawyers live by court rules. And what Hurst just did is like walking into a chess match and trying to play a no. The phrase he scribbled on the envelope, I do not accept your offer to contract, is textbook sovereign citizen gibberish. And legally, it's meaningless. Refusing mail doesn't cancel court deadlines. Instead, it puts Hurst at a disadvantage. Admissions are assumed true if not answered. And that alone could tank his case.
And verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She
right,
cut
I'm going
me
to
off.
mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh
You
my
will speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes,
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand.
He's spelling out in crystal clear terms what happens when you ignore discovery Your silence equals agreement. That's right if you don't respond. It's legally the same as saying yes, that's true. And Hurst's stunned reaction proves he didn't read a single line of the court rules. It's moments like this that expose how dangerous self-representation can be. When you're relying on YouTube law professors instead of actual attorneys. The judge is practically pleading with him open the mail, read the packet, file something, anything. But Hurst is too deep in the sovereign citizen rabbit hole to grasp the gravity.
Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because
Hurst claims he refused the packet because he didn't know if it was a contract offer. Spoiler alert, that's not how lawsuits work. The court doesn't send you a friendship bracelet, it sends you legal documents with deadlines. And his claim that the plaintiff needed to send something 5 days after first contact is total fiction. He's pulling procedures out of thin air. Meanwhile, the judge continues balancing professionalism with low-key roast mode, like when he questions Hurst's ability to tie his own shoes. This courtroom isn't just handling a case, it's managing delusion in real.
Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut.
Peak courtroom parenting. The judge isn't just explaining the rules, he's warning Hurst like a frustrated dad explaining why licking a socket is a bad idea. You have a right to represent yourself, but not your own set of court rules. That line, legendary. The key takeaway is this: representing yourself doesn't give you magical immunity from legal procedure. You still have to play by the same rules as attorneys. The judge even offers Hurst another lifeline, urging him to get legal counsel. But you can already see where this is going. Hurst is determined to go full crash out.
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, The request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're gonna do what you choose to do. She's gonna send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again.
for me
We had
and
this
her.
conversation before, didn't
Sorry,
we? We
Go
had
ahead.
this conversation before.
go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents.
Round to opens with Hearst reading. Off the classic sovereign citizen starter pack. I reserve all rights. I do not consent. Unrevealed contracts. It's like watching a karaoke performance of a legal TikTok, except it's not just cringe. It's case destroying. Judge Robinson doesn't even blink. At this point, he's seen enough of these folks to know where it's headed. Hearst may think he's asserting some higher law, but what he's really doing is offering the court no valid legal defense. And once we reach the motion hearing phase, that reality becomes hilariously, tragically.
Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any.
Here, it is the final blow. The judge meticulously dissects Hearst's filings and finds them legally useless. No affidavit, no material facts in dispute. Just sovereign words salad peppered with mystical nonsense about living souls and mailboxes. One line reads like it came from a medieval contract fantasy novel, another flat out claims the man doesn't live at the address he used. The judge, unfazed, swings the gavel hard, summary judgment granted. And just like that, the case ends in spectacular defeat. It's a courtroom masterclass in how facts, evidence, and procedures will always win while conspiracy cosplay gets you.
Discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to.
Folks, that's the courtroom equivalent of a mic drop. Kevin Hurst tried to outmaneuver the legal system with jargon and mail rejections, and got crushed by basic procedure. This wasn't just a win for Midland Credit, it was a win for logic, law, and patient judges everywhere. Judge Robinson's composure, paired with low-key roast moments, made this a perfect example of how courts handle sovereign antics with class and consequence. So, what did you think? Could Hearst have saved himself with a lawyer? Drop your thoughts in the comments below. And if you found this breakdown satisfying, hit that like button, subscribe with notifications on, and share this video with your legal savvy friends. Courtroom chaos never rests, and neither do we.
Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank?